Good afternoon, everyone. Thank you for joining our webinar today. I'm Mike Phillips. With me is Don Stetter, my colleague at McGuireWoods, and we're both labor and employment attorneys. Our topic today is labor and employment trends and hot topics. So I wanted to give everyone just a quick roadmap of what we're going to try to cover today. And then Don and I are going to discuss a series of issues. But what topic could be hotter right now, of course, than the coronavirus? And so we've focused this discussion quite a bit on issues related to the coronavirus and how it's affected the workplace. We seem to be at a point in this saga where there's actually some hope that employers will be able to, if not resume pre-pandemic operations, at least have some chance of, I guess we're calling now normalcy. But for employers, that also raises a number of issues of how they're going to manage a workforce that, for some employers, has been out of the office and predominantly working from home. And for other employers have been coming to the workplace, but with a number of precautions. So one of the issues that we're hearing a lot about from employers is how to handle vaccination, and including whether an employer can require employees to be vaccinated as a condition of working. So we'll spend a good amount of time talking about that and the new EEOC guidance on that subject. We want to talk a little bit about work from home and how the pandemic and the work from home environment that many employers have adopted is going to affect the return to the workplace and whether work from home is here to stay. You'll be pleased to know that the pandemic has not stopped the flow of class action lawsuits against employers, and one of the big areas that we're seeing in terms of class actions is our biometric privacy laws, especially here in Illinois, where Don and I both are. But biometric privacy is expanding to other states as well, so we want to spend some time discussing those issues. And then you may have heard that we have a new president and a new Department of Labor and a new EEOC chair. So we'll try to spend some time towards the end of the webinar discussing the labor and employment agenda of the Biden administration and some changes that we might see in the next 4 years or so. We do want to encourage you to ask questions, and you should be able to submit questions to us through the Q&A tab on the bottom of your screen. Don and I are going to do sort of a Q&A format ourselves and interview each other about these issues. We're going to try to work your questions into that discussion if we can. If not, what we will try to do towards the end is spend a few minutes trying to address questions if we have some questions in the application. So please feel free and be encouraged to submit those questions about what we're going to discuss, and as I said, we'll try to address as many as we can. So, Don, I think the first thing we wanted to talk about was vaccines, and there's a new EEOC guidance that some of our audience may have heard of. Can you tell us a little bit about what that guidance says about vaccines and what employers can do and can't do?
Certainly. So you all may have noticed it came out sort of at the end of last year, end of 2020, the EEOC, as vaccines were starting to hit the market, weighed in on whether employers can require their employees to get the vaccine. I don't think that anything, if you've read through it or you're aware of it, I don't think that anything that's in the EEOC's guidance is all that different than the state of law before the EEOC issued the guidance. But sort of at a high level, what the EEOC says is they sort of start from the premise that employers can require the COVID-19 vaccine, and then they go on to answer a series of questions. And so, they start with the premise that vaccines are permissible, but as always with anything, there's exceptions. And those exceptions are, if an employee cannot take the COVID vaccine because they have a disability or they have a sincerely held religious belief, the EEOC is of the position that you need to go through your interactive process and determine whether any accommodations exist that might allow that person to still be in the workforce. And I think, particularly with disability, and even with religion to some extent, those accommodations I think are pretty well known: masking, social distancing, hand washing. So I don't know that anything in here is necessarily groundbreaking, but it's just important to remember that if you are in a position as an employer where you're going to be mandating vaccines, that it's really important to still consider whether somebody might be entitled to an accommodation under either the ADA or Title VII for a religious exception. In terms of administering the vaccine, depending on what industry you're in, some employers, this might be easier than others, where they have someone come on site to administer the vaccine. The guidance also sort of addresses what type of pre-vaccination screening questions that an employer can ask. And I think the general rule is if you're, as an employer, going to be asking medical questions, that you need to make sure that those questions are both job-related and consistent with business necessity. Now, if the employee is getting the vaccine off-site, there's a little bit lesser standard. You don't need to necessarily worry about meeting the ADA standard, but the key and the critical issue there is that if the employer is requiring the vaccine and it's coming on site, you just need to make sure that any questions that are asked are consistent with the ADA standards. And similarly, along those lines, any questions that are asked should be mindful of not asking information that would require an employee to elicit genetic information. And I think the final point that it addresses is whether or not an employer can require proof of vaccination. And the answer there is yes, so long as you meet the confidentiality standards that attach to any other employee in the workplace that provides medical information. So ultimately, I don't think, I'm Mike interested in your view on this as well, but I don't think that there's anything groundbreaking here, but good reminders on, best practices with respect to how to engage in the interactive process when there's something like a mandatory vaccination requirement.
Right, and I think that's right, Dawn. And the headline of this guidance, of course, was saying that an employer can require vaccines, but then when you start to look at more of the fine print of the guidance, I agree with what you said. It's not a lot different or different at all, really, than the position the EEOC usually takes, which is that if somebody has a disability-related reason why they can't get a vaccine or a religious objection to getting a vaccine, then you need to try to accommodate those objections. And one thing that I think stood out to me as well was that the guidance is that before removing excluding an employee from the workplace because they don't have a vaccine, an employer needs to look at whether the employee can be accommodated in some other way rather than working in an office environment or in a factory environment or a manufacturing environment. So it seems to me that you may, as employers, be still required to allow employees who don't want to get a vaccine to work from home if that's what they've been doing during the pandemic. Dawn, did you read it the same way, that we may be seeing sort of a continuing duty to accommodate with work from home arrangements, possibly for quite a while?
Right. Yeah, I agree with that. And, too, I think just the fact that so many employees have been working remotely or performing at least some or all of their job duties remotely, sort of, if an employer wants to sort of take a line in the sand and say, no, that's no longer allowed, I think you have to be really mindful of the fact that it's very difficult to make an argument that there's an undue hardship in allowing someone to continue working from home when they've been doing it for a year. And that I think probably goes across all contexts, even if someone was looking for a disability accommodation not related to the COVID-19 pandemic.
Right, right. So, I haven't heard a lot of employers, either in the healthcare sector or otherwise, mandating vaccinations at this point. What have you been hearing from employers? Do you hear them, going in that direction?
Yeah, so I'd say almost all of the employers that have spoken to me about it have elected at this point not to require the vaccine. And I think there's a lot of reasons that kind of go into this calculus. I think first and foremost in everybody's mind is sort of the vaccine. It's difficult to get, and so making it mandatory, I think, poses challenges, certainly in this environment when, the rollout has been, I think, fairly slow in most places in the country. And I think there's other concerns too, and we kind of put some of these up on the slide. Are there liability risks? Are there increased risks to the employer if they do require the vaccine? And I think that there are some concerns there. I don't know, Mike. What do you think? Do you think that employers are concerned about making the vaccine mandatory and incurring liability in different areas?
Yeah, I think that employers probably have some risk both ways, right? But I think that most employers, I think, have the sense that it's just too controversial right now. It's going to cause, in addition to legal liability issues, just concerns among the workforce, objections from certain employees that may or may not be framed in religious or disability grounds, but that the disruption that may be caused by mandating vaccines could be is going to be greater than the disruption caused by not. So I have seen employers moving towards some other ways of trying to encourage employees to get vaccinated, such as incentives, paid time off, even bonuses. Don, have you been seeing the same thing in terms of employers that are looking for ways to incentivize vaccination rather than mandating vaccination?
Yes, yeah, that's certainly something I've been seeing on the ground, and I think the question I get most frequently is, if we're going to incentivize employees, how do we do it? What does that look like? Because I think employers at this point are more interested in the carrot than the stick. And I think, like you just said, Mike, some of the things that I've heard are giving extra paid time off to go get the vaccine, maybe offering a small bonus. But I think one of the things there is, you're going to be offering a monetary incentive, like a bonus, to something like a non-exempt employee, that could trip you up on wage and hour issues, given that, that if that person works overtime, it's something that should likely be included in the regular rate. So I think you have to be very careful in implementing any types of incentives. And I know there's been lots of back and forth, especially with the change in administration. I know the EEOC had just at the end of January issued a series of regulations on health and wellness and what type of incentives you can provide in the context of a health and wellness plan. And within days of the Biden administration coming into the office, they froze all those regulations. So it's something where there is a little bit of back and forth given the change of administrations as well. So definitely a topic that a lot of employers, I think, are interested in right now.
Yeah, and to your point about regular rate, I just had my first client sued for not including a hazard pay or a essential worker bonus, they called it, to incentivize employees to come into a manufacturing facility. And they were sued because while they paid the bonus, they didn't include the bonus in the regular rate calculation. And I think that that if you're giving financial incentives to employees to be vaccinated, one thing that employers need to make sure they're doing is including that money in the regular rate calculations and letting their payroll providers know that it needs to be included because that may be the next wave of class actions, unfortunately, is addressing pandemic and vaccine-related incentives. But, it is, I mean, do you agree that it is permissible for an employer to provide incentives to be vaccinated? But could an employee who's pregnant or who has a disability, say that they're being discriminated against because they can't be vaccinated and therefore they're not eligible for a bonus? That's the only, real, that's the other legal issue, I should say, that I see with those programs. Would you agree that could be an issue?
Yeah, no, I think that could be an issue, and I think that's why employers that are considering sort of these incentives, I think you would need to, if someone says I can't take the vaccine, so I'm not eligible for the incentive, I would think that the best course of action there would be to have some sort of backup plan so that you're not sort of unfairly penalizing either, like you said, a pregnant employee or somebody who has a disability or religious accommodation, because you could easily see where someone might use that to say, this is unfair, this is creating an undue burden on people with disabilities and, religious objections to taking the vaccine in the workplace. So I think it would have to be administered really carefully. Another thing that sort of struck me too is, for employers with unionized employees, how this all plays out there. I think that this is something that if a unionized employer wanted to roll out, I would assume that would be something that would have to be bargained over. So there's a lot of additional layers there to the extent that there's a unionized workforce. I don't know if you've had that come up at all, Mike.
Yeah, no, and that's a really good point. I think that absolutely it would be a subject of bargaining if you were going to mandate vaccines. I don't think an incentive program is something you would necessarily need to bargain over with the union, but it could be a subject of permissive bargaining. But I definitely think that mandatory bargaining, mandatory vaccination is something that would need to be discussed with the union. One other issue that kind of struck me, and I'm curious about your take on it, is, what if an employee who has a health condition that puts them particularly at risk, or is pregnant, or, has some other specific concern about coronavirus, comes forward and says, well, I don't feel like I can return to the office or return to the workplace until everybody's vaccinated. In other words, unless you mandate vaccines, I'm not coming back. Do you think there'd be a duty of accommodation to those employees as well? Maybe not mandating vaccinations, but continue to work from home or some other form of accommodation.
Yeah, I mean that's a great question, and I also think it's a loaded question too, with maybe not exactly the precise guidance that we might like to see. But I think if someone is saying that they're not comfortable coming back, and that there's a disability or there's some other sort of protected reason that they can't come back, my thought would be go through the interactive process, see what the concern is, see whether it can be mitigated, and work it that way. You certainly want to be careful of the perception issue and not sort of, as an employer, imposing your own perception about who can come back to the workplace and when. But it's definitely one of those situations where I think you have to proceed very carefully. I don't know, what are your thoughts, Mike?
Yeah, I mean, my thoughts are the same. I mean, I think that if it's disability related, I think you can request medical information. But, the thing that's a little bit tricky, I think, is that some risk factors such as age and weight, are not necessarily disabilities, although age is protected in other ways. But, so it makes it a little bit tricky too. Are you going to treat someone who has a disability, has a risk factor, which is a disability, different than somebody whose risk factors might not otherwise be protected under the law? So it's a tricky question. It's something that hasn't come up, but I do think that probably the default position for employers should be, at least for the time being, to try to accommodate it, and possibly over time can move more towards a regime where everybody is vaccinated, or we're in a state as a country where the infection rates in the community are low enough that you can maybe, say that folks need to work in the office regardless of their risk factors. But, for now, I think probably that accommodation of, concerns on either end is a safer course. One thing also I wanted to, ask you is, is it time, once your employees get vaccinated, is it time to get rid of the other restrictions in the workplace, such as masking, social distancing, and wiping down surfaces? When can employers expect to be done with that?
Yeah, I think that's a great question, and it's one that I've been asked. Particularly in the healthcare context, where we're seeing higher rates of vaccination, earlier rates of vaccination. Can we just do away with social distancing and masking? And I think the answer there is no. That we should continue to encourage masking or require masking, social distancing in the workplace for a couple reasons. I mean, first of all, that's certainly what the CDC's position on the matter is, that, there's not a lot of scientific data on whether somebody who's been vaccinated could be a spreader or even a super spreader in the workplace or anywhere for that matter. So, we do know that masking is working and continues to work. In fact, I was just listening to the radio the other day, and one of the things I think the CDC is on the verge of recommending is actual double masking, which is interesting, trying to get people to wear just one mask. I think some places have found challenging, so I don't know how it would go over to say you need to wear both a surgical mask and a cloth mask. But I certainly think masking, social distancing, and those sort of protective measures are in our future for a while. And another issue I think I've had come up a couple times is, somebody's vaccinated and now they want to start traveling, and how you handle that, particularly in jurisdictions like Chicago or other places where the city or state says that there has to be a mandatory quarantine or negative COVID test. And, my guidance on that has been, if you're allowing employees to travel and employees are traveling, they can travel, but they certainly have to follow whatever the state and local guidance is there. I don't think the vaccine is a game changer with respect to, either protective measures or complying with applicable law and quarantines. So it's an interesting issue that I think will continue to evolve.
Yeah, and I agree on the travel quarantines, not only, for the reason that you need to comply with state and local travel quarantine requirements, but I also think it's going to be difficult, at least in the short term, to try to treat vaccinated employees differently than non-vaccinated employees with respect to things like quarantining after travel. I think you're going to run into some situations where if you try to exempt vaccinated employees from some of these requirements, it's going to cause confusion. It's going to cause a feeling of being unfairly treated or treated differently than coworkers, and it may undermine the entire effort to try to encourage safe and healthy workplace practices. So I think in general I would probably discourage employers from creating exemptions to these health and safety protocols for employees who've been vaccinated. One more question I think we were going to touch on, which is, are employers prepared to pay for the cost of vaccinations? I think the CARES Act speaks to that, doesn't it?
Right, it does. Yeah, the CARES Act does, say that the vaccine is cost-free. But, this has certainly been in the news in the last few days where, the vaccine itself is cost-free. Some pharmacies or healthcare facilities have been charging an administration fee. So, keep an eye out on that. I think I heard somewhere where they said it cost somebody $200 to get the vaccine, not because they had to pay for the vaccine, but because they had to pay for someone to put it in their arm. So it seems like those types of issues are popping up around the country.
Yeah. All right. Well, maybe just transitioning to working from home. I was in our office yesterday. It didn't seem like it was too much more packed than usual, but and I know that there's some employers who have been having employees coming into work in the healthcare space, for instance, and and in manufacturing would be another example. But for sort of the office-based workforce, what are you hearing out there, Dawn? Or do we have employees return to the office, or are most of our clients still primarily remote? What are you hearing about that from employers?
Yeah, I mean, I think a lot of it, like you said, depends on industry. But in terms of the office-based industries and where there has been a lot of remote work, I don't see most of our clients, rushing to get people back into work and to the same physical space. I think at most, a lot of employers are considering a staggered return to the office. The time frames I'm hearing, most frequently is, we're going to get through, the spring and maybe even the summer, and then start talking about really getting back into full swing, this fall. So it's certainly gone on a lot longer than I think any of us would have imagined back in March 2020 that a lot of us office type people would be working remotely. But I don't see that there's going to be sort of a switch that gets flipped and then everybody comes back to work. I think that's challenging from a couple standpoints. Hopefully it looks like the transmission rates are on the downward trend, which is great. But, there's nothing that wouldn't prevent a possible spike happening. And I think the other thing that a lot of employers are confronting is that now that a certain segment of their employee population has been working from home, they're sort of confronting the fact that it's going to be harder to bring people back to work because they're liking the benefits of working from home. So it's certainly an evolving situation, I think. I don't know. I personally think that telework is something that probably is not going to end with the end of the pandemic. But what are you hearing, Mike? Telework here to stay, or what do you think?
Well, yeah, I mean, much the same thing, I think, which is that employers are not in a rush to get employees back into the office. That most employers, I think, have found that productivity has been pretty much the same in a remote environment as it was in an office environment. And just hearing sort of anecdotally, not so much from clients, but just from people I know who work in offices, that there's not a great desire for most of the workforce to be back in a 5-day-a-week office environment. But from a professional standpoint, as someone who represents employers, I do get concerned about employment risks from employees working at home. So, are there some things that you've seen, Dawn, in terms of risk that employers are incurring? I mean, obviously, up to this point, there hasn't been much of a choice, but, now that there may be, we may be transitioning into a time when employers do have some discretion to bring employees back, or there's some, legal downsides of sort of maintaining the post-pandemic status quo, I guess you'd call it, of having a substantial remote or hybrid workforce.
Yeah, I mean, I think when you're talking about exempt employees where you're not as worried about tracking what they're doing and when, the risk is a little lower. But, certainly with your non-exempt or your hourly employees, I think there are challenges with remote work. Particularly, you kind of hear people saying, are you, that they're essentially living at work now. And I think, for us exempt employees, maybe it's not as big of a concern, but for non-exempt employees, obviously it's super important that, we're ensuring accurate recording of their time and making sure they're getting paid for everything that they're doing. And I think pre-pandemic, we sort of saw this as an issue coming up on the horizon a little bit with smartphones, right? Non-exempt employees who are either taking calls or accessing their employer systems from their smartphones at night and not tracking that time, and then lo and behold, a year from now saying they didn't get paid. And I think those types of risks are only heightened when, your quote unquote office is, either at your kitchen table or just, next door to your bedroom. So I think that those are all issues that are popping up. And, so some of the things that, we've been working with clients on doing is just making sure that their making sure timekeeping policies are up to date, reminding people that if they are working overtime, whether there's approval that's required or anything that you kind of follow as an employer when you have employees in the workplace, that, overtime has to be paid. If they're working overtime, they need to be tracking it. And I think, Mike, you had touched on this earlier with, the hazard pay, but, if you are giving employees non-discretionary compensation during this period and they're working overtime, that, you need to be working with your payroll provider to make sure that that is included in the regular rate calculation when employees are getting paid for overtime. And I think that kind of also speaks to sort of the next wave of laws. I've been seeing them pop up, in various places. Illinois has one, Washington, D.C. just passed one, but obviously comes a little bit to the forefront with all these people working from home, but expense reimbursements. I don't know if you've, had the opportunity to talk with clients during this remote work period about how they're handling reimbursement for things like printer paper or things like that, internet, during this work from home. I don't know, Mike, what do you think about how employers are handling expense reimbursement during telework?
Yeah, I mean, unfortunately, I think a lot of them aren't, or they're just starting to. That's kind of been my observation. I'm getting calls from clients, saying, "Oh, we've had our employees working from home for over a year. Are we supposed to be reimbursing them?" So yeah, I think that this was somewhat of an overlooked topic, and probably for good reason, because there were bigger issues to deal with. But I see some employers now trying to get on top of this. And just to clarify, when employees are working from home and they're spending their own money, is the example that you gave was printer paper, but there's other expenses working from home, including cell phones, maybe upgrading internet and other types of expenses that could potentially be claimed under these statutes. Illinois has a statute. California has a very aggressive employee reimbursement statute. What we've seen a lot of employers doing here in Illinois and in California as well is giving employees stipends for work at home expenses, and telling them, if you exceed this amount, you can apply for additional reimbursement. But most employees don't; they just accept the stipend and move on.
Yeah.
And that's one way. I think employees can protect themselves and not have to deal with monthly the administrative burden of monthly expense reimbursement for everybody's printer paper and internet and so forth.
Yeah, and the interesting is, go ahead, sorry.
No, go ahead.
I was just going to say one interesting thing that comes up too, and I think employers deal with it in different ways, is obviously employees are using their home Wi-Fi, and if you are required to reimburse expenses for, say, Wi-Fi, obviously they're not working 24/7. How do you calculate what a reasonable reimbursement would be? And I think your point of a stipend is, that's a great idea. I've seen employers say, okay, well, you spend this percentage of your time working, we're going to give you this much of a reimbursement. So it's a little bit different tack on the same issue.
Yeah. And another concern I think that employers have with work at home arrangements, or need to have, is protecting confidentiality. And this comes up, for us in trade secret cases, where if you want to enforce a trade secret, one thing you've got to show is that you took reasonable measures to protect confidentiality of the trade secrets. So, in an office environment, typically the way that would be done is with password-protected computers and restrictions on removing printed documents from the workplace and other measures such as that. But how does that translate to a work-at-home environment? And is there anything additional to the regular confidentiality, information security policies that employers should be doing to try to protect confidentiality of data and trade secrets?
Yeah, I mean, it's certainly a challenge. I think, one thing that always is on the forefront of my mind is, if somebody prints something out, how do you handle it? And so certainly on your more sensitive data, disabling the ability to print, making sure that, somebody can't save a copy to a local hard drive, or, accessing computer systems or accessing the employer systems through a home device. I think those are sort of basic steps you could take to make sure you're protecting your confidential information while employees may be accessing trade secret data or confidential information, from a home setting. So I think important things to consider.
Yeah, and then a couple of specific concerns I have about that, would be employees printing documents and when they're done with them, dumping them in the recycling bin out in the alley, right? Or also,
right.
Employee doesn't feel like going, upstairs to get on their work computer, so they log on with their son's iPad, right? And then expose the iPad to work-related data, or expose work-related data to someone else's device, where it could be downloaded or accessed again. So I think those are some real risks, and I do think that employers are well advised to put some policies in place around that, such as either no printing, restricted printing at home, as you suggested, Dawn, or a rule that anything printed at home can't be discarded. It needs to be brought back into the office or collected somehow and securely disposed of. And likewise, if you have employees working from home, preferably they're working on company-issued equipment and not on their own equipment, where they can access, remotely through a Citrix connection, so forth. Some employers don't have equipment for every employee, but when you are authorizing remote access from home, it does create some risks in terms of disclosure of confidential information, and also then how do you prove that you've taken reasonable measures to protect confidentiality when you have employees who might be logging on any device that they choose. So I think those are all risks that we need to consider.
Yep.
Another work from home issue that I've given a lot of thought to is what happens post pandemic when an employee says, "Well, I want to work from home full time as an accommodation for a disability or an accommodation for pregnancy or other issues." And I can tell you that 2 years ago, 3 years ago, a lot of employers would say, "Well, we don't allow people to work from home," or we allow you to work from home, but you can only work from home, 2 days a week, and it has to be a day of the week that starts with the letter T, and you have to, come in the office.
Right.
Well, we want you to be in the office, and so forth and so on, right? And how do you, maintain those kind of restrictions and justify them legally when many employers have had, substantially all their staff working remotely for a year, and does it kind of change the employer's obligations around work from home accommodation?
Yeah, I think you're completely right, and I don't think that there's a really great black and white answer to that, because once I think an employer has shown the ability to allow work from home, it's a lot harder to say, there's an undue burden. And, and maybe there's an argument to say that during this work from home period that, the employer has provided, invested additional, capital in temporary work from home support, whether that's IT support or a different infrastructure, and that's coming to an end, and therefore you need to be back in the office. But I think that the answer, post-pandemic would probably be the same as it was pre-pandemic, is if you have an employee who's asking for, a work from home accommodation, it's important to go through the interactive process and to understand, what are the limitations? Are there anything else? Because I think the ADA does say that, employees are entitled to an accommodation. They're entitled to a reasonable accommodation, but it's not always the accommodation of their choice. So maybe if you don't want to allow, complete work from home, maybe there's a different accommodation that might enable the person to come back to work and perform the essential functions of their job. So it just makes going through that interactive process even more important, I think.
Yeah, I think so too. Just one more question about work from home, maybe a little more short term is, we still have a lot of people whose kids are in school and schools are not open, or have other reasons why they need to be at home and can't come into work. Is there any right now any statutory requirements for employers to provide work from home or telework accommodations for those employees?
Yeah, that's a great question. And, I think, in some respects, we know that at least for the time being, and if we have time, we'll certainly touch on what the Biden administration has to say about this. But, for the time being, the FSCRA is sort of off the table. So you're left with, as an employer, kind of looking at what state and local laws might apply. Because, as as employment lawyers are well aware, there's definitely a patchwork of, paid sick leave obligations across the country. So obviously if someone's asking for that accommodation, needing to work from home or some other time off because of a school closure, I think the first thing to check, and one of the more important things to check is, what does the state and local law say on it? Is there any component of the paid sick leave that allows that? Is there a mini FMLA in the state that allows employees to take time off under that statute? Another law that I've seen sort of impacted by this school closure across the country, and certainly not every state has this, but California certainly has it, is the school activities leave. As an employee entitled to time off there. And like I said, certainly with the new administration, paid leave is something that's part of that, the American Recovery Act, and we can kind of touch on that maybe in a little bit, but always important to check the laws where you're doing business to see, what an employee might be entitled to there.
Yep, and we'll try to hit some of those before the end of our session today. I thought maybe we could move on to biometric privacy, and maybe, Dawn, you could just explain a little bit about what that means. In my experience, it's something that some employers have heard about and some employers haven't, and maybe specific to what the requirements are here in Illinois for that.
Right. So Illinois, and I think at the time, Illinois was the first state to pass a biometric information privacy law, and essentially what it says is that an employer who stores an employee's quote-unquote biometric information, Mike maybe can talk a little bit about where the wiggle room is there in a second, but employers who store biometric information have to comply with various notice and consent requirements, essentially telling employees that you are collecting their biometric data, and they're consenting to that. And I think the area where it most comes into play is employers who take finger scans for timekeeping systems, and I think less frequently comes up with retina scans. But generally, a biometric data is, some personally identifying essence of your person, like a fingerprint or a retina scan. I'm sure there's other types, but those are the main two I've heard. Mike, have you, in your experience, other types of biometric information that employers have?
Well, no, those are usually the main two, but it can be just about anything. I mean, certainly DNA information, if an employer were to come in possession of that, would be biometric information, but it can be just about any information that could is unique to a person and could identify them. So it's very broad, but like you said, it's the place where we see it the most, at least in the employment arena, is fingerprints, timekeeping systems, and what I've seen a lot is that employers are using these fingerprint systems. They don't really know how they work. They're sold this system by a vendor or by a payroll provider who tells them, oh, it's great, it prevents time card fraud, and doesn't tell them that they need to take certain steps to implement that system to comply with biometric privacy, or tells them not to worry about it, that their system is exempt somehow, and then they find out later that that's not correct. And yeah, I think our slide says there's hundreds of lawsuits filed. I feel like I've seen hundreds of lawsuits filed just since the beginning of the year on this issue. So it's a very very hot area of class action litigation. But what's an employer supposed to do in Illinois if they do have a fingerprint timekeeping system or otherwise collecting biometric data? How do they avoid liability for that?
Well, the first thing we recommend is having a biometric information policy, making sure that you're explaining to employees what you're doing and how you're doing it. And then the next part, which is equally or perhaps even more important, because this is what sort of forms the basis of lawsuits, is making sure you have a notice form that employees are provided that meets the requirements of the statute. And certainly in Illinois, the statute does set forth the requirements. Unfortunately, they are not as crystal clear as we might like, but there's statutory guidance on that. And then as part of your notice, you also have to get consent from employees. So making sure that you have the appropriate notice and consent forms. And I think Mike, you mentioned how many lawsuits they've just seen since the beginning of the year. I think we can kind of continue to expect the lawsuits. There's not a whole lot of cases, at least that I've seen in Illinois, that sort of flesh out what these sort of holes in the statute left. But in 2019, the Illinois Supreme Court had a landmark decision where they said that employees don't even need an actual injury to recover penalties, which I think is, at least in part, sort of generating this new trend of class actions in this area.
Yeah, and there's a number of open issues about biometric privacy in Illinois that are just being resolved now by the court. So it's a very difficult and sort of a risky area for employers right now. But we're expecting to see a couple of clarifications over the next year or so. One is there's an argument being made by some employers that the workers' comp statute preempts biometric privacy. So in other words, employers really aren't subject to biometric privacy issues. There's an issue about what the statute of limitations is, whether it's 5 years or 1 year or 2 years, and employers don't usually have to worry about that, but if you get sued, it can have a big impact on damages. But the big concern right now for employers is, what's a violation of the statute? So in other words, you have an employee using a fingerprint scanning timekeeping system, and you don't have the policy in place, you don't have the consent from that employee. What are you stuck for? The law says it's $1,000 for a violation and $5,000 for a willful violation. But does that mean that it's $1,000 for every employee, or is it $1,000 every time that employee puts his thumb on the timekeeping system and scans in and out, right? And it's obviously a huge difference. So there's a case right now on appeal called the White Castle case. That's going to decide that question. If that case comes out badly for employers, it's going to multiply the amount of damages in these cases exponentially. And there's no real cap on it. So if you think about an employee at $1,000 a violation who's clocking in and out maybe 2 to 4 times a day over the course of a year, I mean, you can do the math yourself, but you probably don't want to if you want to sleep all night.
Maybe not.
It's an exponential amount of money. And so, I raised that point, really not just to scare people, but to say that this is something you should get on top of if you are using a biometric timekeeping system or other biometrics in Illinois, and now in California, Texas, New York, and other places that have these biometric privacy statutes. It's really an issue that they should get on top of, because it's very unpleasant to get served with a class action lawsuit on this basis and find out that you haven't done what's necessary to do under the statute. So maybe we could spend, Dawn, 5 minutes on the Biden administration and the new laws in place, unless we have any questions from the audience. I don't think we do.
Yep, I don't think so.
So maybe just, as I mentioned, we have a change in administration. I'd expect ideologically and philosophically probably a big difference between the current administration and the previous administration. What do you think we can expect to see in the next year, 2, 3, 4 years from the current administration on the employment front?
Yeah, no, you're entirely right. And, in some respects, some of the changes have been very swift. I mean, the day Biden took office, the next day. But, I think right now the big thing that is taking up a lot of time, certainly with the new president and with Congress, is, President Biden's American Rescue Plan. And, and as part of that, there's a lot of pieces of it that do sort of touch on labor and employment, namely sort of this idea that there will be a renewal of the FFCRA mandates, and not only, renewing those mandates, but expanding the law to require, employers who have more than 500 employees to provide FFCRA leave. I think, part of that American Rescue Plan is to try and close up the loopholes so that more employees are eligible for those leaves. They want to not only get FFCRA back in business, but they're talking about increasing the amount of paid FMLA leave to 14 weeks. And one of the things that I've heard as sort of support for that is, people are still, like you mentioned earlier, Mike, dealing with school closures, making sure that employees can continue to work even though their children are home, or, and have job protected leave. For smaller employers, as part of the American Rescue Plan, they're saying those tax credits would still be available. Unfortunately, employers with more than 500 employees, really not going to get the tax credits. It's really going to be on your own dime. Right now, the plan is it's sort of making its way through Congress would be to have these types of FFCRA mandates go through the end of September. But, there's a lot of road to cover, I think, between now and, getting it through Congress. So we'll have to see where that ends up. And I also heard a lot of chatter about, new and more aggressive OSHA standards. You guys may all recall that OSHA really hasn't had any mandatory standards that relate to COVID. It's all been guidance, and certainly that continues to be the case today. But I've heard that one of the priorities is having OSHA sort of weigh in a more forceful way about what type of workplace and health and safety requirements should be in place during the pandemic. A lot of people talking about increased minimum wage to $15 an hour. In some parts of the country, we're there, almost there, but talking about, increasing the federal minimum wage. And then another thing that I've sort of just seen even in my own practice, and interested to get your thoughts too, Mike, is the EEOC taking on certainly a more employee-friendly focus. I think that the emphasis is likely going to be on systemic issues like pay equity and systemic bias, but I would expect the Biden administration is going to use the EEOC as sort of a means to advance that agenda. What do you think, Mike?
Yeah, no, I'd say that's right. I mean, it's typical of what we've seen, certainly in Democratic administrations in the past, is a much more aggressive stance, and I think you're right. I mean, I think the EEOC, even during the Trump years and previous Republican administrations, has still been active in processing charges and doing investigations on sort of individualized employee issues. But I think what we're going to see is more of a policy role for the EEOC, tackling systemic issues, like we saw in the Obama years. Regarding background checks, they're going to pick some policy priorities, and they're going to move very aggressively and using their powers to try to enforce those laws or enforce their interpretation of the laws, at least as it relates to those policy issues. So, and then I guess one more thing we wanted to touch on was the law around independent contractors. We've kind of seesawed back and forth with the Obama administration basically saying there's almost no such thing as an independent contractor. The Trump administration trying to push back on that. What's your expectation there?
I think we're probably in line to see a return to the Obama era position. I know some states, Virginia of all places, have started passing laws where, the presumption is that people are employees. So, in some respects, obviously it's important what happens on a federal level, but, I've seen in the last year, 18 months, a lot of movement at the state level to say, independent contractors, we really don't like that. We treat everybody as employees. So it's definitely an area where I get a lot of questions.
Sure. Well, I think we're at the end of our time, but I want to thank everybody for participating. I hope this was helpful and gave everybody something to think about. If you do have questions that are burning in your mind, or you think of after the webinar is over, please feel free to reach out to either one of us. We're happy to interface with you and answer any questions you have. But I think that's everything that we want to talk about, and what to expect, or some issues at least to expect in the next year or so. So thanks everyone again.
Thanks everybody.